Now I am going to dictate a legal passage at the rate of 100 words per minute based on latest Supreme Court judgment. Let's start. Mr. X, learned senior counsel, relying on the decision of this court in N. Balakrishnan versus M. Krishnamurti within bracket 1998-7 SCC 123 submitted that length of delay is no matter and acceptability of explanation is the only criterion. It was submitted that if the explanation offered does not smack of malafide or it is not put forth as a part of dilatory tactics, the court must show utmost consideration to the suitor. The very said decision upon which reliance has been placed holds that the law of limitation fixes a lifespan for every legal remedy for the redress of the legal injury suffered. Para. Unending period for launching the remedy may lead to unending uncertainty and consequential anarchy. The law of limitation is thus founded on public policy. The decision does not lay down that a lethargic litigant can leisurely choose his own time in preparing appeal or application, as the case may be. On the other hand, in the said judgment, it is said that court should not forget the opposite party altogether. It was observed within bracket SCC P. 128, para 11, para. It is enshrined in the maxim interest. It is for the general welfare that a period be put to litigation. Rules of limitation are not meant to destroy the rights of the parties. They are meant to see that parties do not resort to dilatory tactics but seek their remedy promptly. The idea is that every legal remedy must be kept alive for a legislatively fixed period of time. Stop para. In construing Section 5 of the Limitation Act, it is relevant to bear in mind two important considerations. The first consideration is that the expiration of period of limitation prescribed for making an appeal gives rise to right in favor of the decree holder to treat the decree as binding between the parties, and this legal right which has accrued to the decree holder by lapse of time should not be light-heartedly disturbed. The other consideration which cannot be ignored is that if sufficient cause of excusing delay is shown, discretion is given to the court to condone the delay and admit the appeal. Para. It is further necessary to emphasize that even if the sufficient cause has been shown, a party is not entitled to the condonation of delay in question as a matter of right. The proof of a sufficient cause is a condition precedent for the exercise of the discretionary jurisdiction vested in the court by Section 5. This aspect of the matter naturally introduces the consideration of all relevant facts, and it is at this stage the diligence of the party or its bona fides may fall for consideration. Para. On the facts and in the circumstances, we are of the opinion that the respondent beneficiary was not diligent in availing the remedy of appeal. The averments made in the application seeking condonation of delay in filing appeals do not show any acceptable cause, much less sufficient cause to exercise court's discretion in its favor. Para. In the case of Isha Bhattacharya versus Managing Committee of Raghunathpur Nefar Academy and others, within bracket 2013-12 SCC 649, this court made the following observations. Para. From the aforesaid authorities, the principles that can broadly be called out are: there should be a liberal, pragmatic, justice-oriented, non-pragmatic approach while dealing with an application for condonation of delay, for the courts are not supposed to legalize injustice but are obliged to remove injustice. Para. The terms sufficient cause should be understood in their proper spirit, philosophy, and purpose, regard being had to the fact that these terms are basically elastic and are to be applied in proper perspective to the obtaining fact situation. Para. Substantial justice being paramount and pivotal, the technical considerations should not be given undue and uncalled for emphasis. Para. No presumption can be attached to deliberate caution of delay, but gross negligence on the part of the counsel or litigant is to be taken note of. Stop. Thank you.